My name's Ben Andriazzi, and I'm a partner with Andriazzi and Foote, a law firm who is dedicated to representing child sexual abuse survivors in civil cases. Today we're going to talk about a very difficult topic, and that is, what should you do legally after your child has disclosed sexual abuse? We're going to talk about mandatory reporting, but we're also going to talk about what you should do next and what you can expect will happen in the process after you make that report that your child has disclosed to you they've been sexually abused. No parent wants to go through this, and it's a very tragic situation, but our goal is to provide you with as much information as we can to help your child on a path to healing and recovery. In other videos and other information on our website, you'll be able to find tips and strategies in how you can support your child emotionally and give them the services and resources they need. But today, this video is designed at educating you on your obligations and what to expect next after you've made a report that your child has disclosed sexual abuse. So the first issue is really mandatory reporting. There are who, what's, when's, and how's when it comes to mandatory reporting. And every state is a little bit different, but we do see common themes in the different states regarding mandatory reporting. The first issue is who's responsible for mandatory reporting. Generally, you as a caretaker or person that is responsible for the supervision of your child has a legal obligation to disclose to law enforcement and the Child Protection Services Agency that you reasonably believe that the child is being sexually abused. So what must you disclose? This is a very a common question that we hear is, do I only have to disclose sexual abuse if the child has told me there's a touching of an intimate part of their body? Well, that's obvious. The answer to that is yes, that constitutes sexual abuse and therefore must be reported. But what if it's more nuanced? What if the child discloses having been touched but not in a private part of their body? Or what if the child discloses what is commonly referred to as grooming? Maybe some sort of behavior which doesn't involve touching, but clearly has an inappropriate tone to it and is designed from the perpetrator's perspective to elicit some sort of a sexual response. Well, that obviously, in our book, needs to be reported. We always say if there is a question of whether something should be reported or not, always err on the side of reporting. So the takeaway here is reporting obligations include not just physical touch, but also grooming and other sorts of inappropriate behavior. When should the sexual abuse be reported? And the answer to that is as soon as possible. I mean, if you're in the middle of the desert or in the mountains and your phone doesn't work, you're not going to be arrested because you weren't able to make that report, within 30 seconds of the disclosure. But the reality is that the disclosure, once you hear the disclosure, you should make the report as soon as possible. Who should you make the report to? And generally, the report should be made to two agencies: law enforcement and the Child Protection Services Agency in your area and in your state. Generally, reporting to one of those two agencies will fulfill your legal obligations, but we always recommend that people disclose to both of those agencies simultaneously. So now that you've made the report that your child has disclosed something to you, what can you expect will happen next? Well, often the next step is a physical examination. Your child will be asked to travel to a medical facility that has either a doctor or a sane nurse or other medical professional who has experience reviewing evidence, physical evidence, such as DNA or bruising that may be indicative of sexual abuse. So your child would go into the medical facility, they would be asked a host of questions, and if there is an opportunity to extract some sort of evidence from your child, that's what those medical professionals would do. And it can be invasive and it can be traumatizing for children. And that's why we think it's important that you be equipped with all the information and tools possible to help your child through this process. So after the physical examination is completed, your child may be asked to go to a children's resource center for a forensic evaluation. And during that forensic evaluation, generally a psychologist or a social worker who is skilled in questioning children about child sexual abuse will ask a host of questions to your child in a room. Sometimes the room will have a drawing board. So for young children, the evaluator is able to draw a stick figure maybe, point to different areas of the stick figure, ask questions about whether touching happened in different areas of the body. Sometimes that room will have a mirrored wall. And in some resource centers, parents will be allowed to be on the other side of the mirrored wall so they're able to observe the child going through the investigation. But what you should do before your child goes in for this forensic evaluation is ask the resource center what you can expect. How long is this going to take? Will I have an opportunity to observe my child? What sorts of things do you expect to be asking my child about? How are you going to ask these questions? Those are generally fair game. What you don't want to do is interfere with the integrity of the evaluation or in some way coach your child in a manner that could render the evaluation incomplete or inadmissible in court. Because after all, it is vitally important that the evidence be obtained to prosecute the perpetrator of your child. And it's important to understand the difference between what CPS, the Child Protection Service Agency, is doing, which is ensuring the safety of your child. Is your child in a safe environment? And what law enforcement is doing. Law enforcement's job is different. Law enforcement's job is to take the perpetrator off the street and hopefully put them in jail and to remove them from society so they can't hurt other people. So after your child has gone through the physical examination and after they've gone through the forensic evaluation, oftentimes law enforcement will seek to continue an investigation and seek your cooperation to obtain evidence. The most common evidence that they'll try to obtain is physical evidence, maybe DNA on sheets, on blankets, on clothing. So they may ask you for those sorts of items. It's also common that they will ask parents for access to electronics, which may have valuable evidence stored on them. Communications between the perpetrator, where the perpetrator may have admitted to doing something inappropriate with your child. So they may ask for access to a computer, to a tablet, or to a cell phone. After the police acquire and obtain as much information as they can and they work with the Child Protection Services Agency, a decision is made as to whether they believe they have probable cause to prove that a crime has occurred. We will provide you in other videos and information throughout our website, information on what you can expect through the criminal phase. So again, we're here to support you, and we are here to provide you with as much information as possible to help your child get through this unfortunate and terrible situation. And if you have questions about what to do after your child makes a disclosure or what the process looks like, please, please feel free to reach out to us by email or by phone. That's why we're here, to support you and help your child on their journey to recovery.